So we have three panels today. We told you we would get you out of here by 11:15, and we will. It'll be efficient, but it will be beneficial. The first panel, which I'm going to introduce in a moment, is going to talk to you about recent trends in arbitration and very significant practical benefits to arbitration clauses. The second panel of experts will deal with third-party funding, something you probably don't know very much about, but hopefully by the end of today you will want to know a lot more, because it's an extremely beneficial advantage for parties in disputes, and I will explain that to you in a minute. And then the third panel of experts is going to tell you about the growth of investment treaties and why that matters to you, especially if you're doing business in higher risk parts of the world and you're investing your money there. So let me introduce to you the first panel that are sitting here, the esteemed. So my name's Bob Armstrong, and the gentleman in the middle is Robert Armstrong. And he wanted me to make sure to tell you that we're not related. Bob is a former Court of Appeal judge, a former head of the Law Society of Upper Canada, a very senior and highly regarded trial and arbitration lawyer at the law firm Torys for many years, and is now an independent arbitrator at Arbitration Place in Toronto. There are probably few people that you could imagine having here that would know more about disputes and the practical resolution of disputes than Bob Armstrong. Sitting beside him on his left is Gordon Bell, senior partner in our office in London. He's an international arbitration specialist, has done a great deal of work around the world for UK and international clients. His areas of focus include construction, energy, oil and gas, shipbuilding, infrastructure, defense, and he's been ranked as one of the best lawyers in the UK in the arbitration field. And on this side is John Callahan, one of the most senior partners in the litigation group in Toronto. If you read the Globe and Mail anytime in the last 2 years, you pretty much see John on the front page of the ROB every week. He acts for large corporations, governments, regulated industries. John's also a member, an elected member as a bencher of the Law Society, and is extremely experienced as a trial lawyer and an arbitration lawyer. We're very lucky to have these three panelists take us through the first issues. So let me start off by asking Gordon a basic question. What are the most common types of disputes that you see as an arbitration lawyer around the world?
Thanks, Bob. I think probably when Bob told you what was on my CV, you probably guessed what are the kind of areas of international arbitration that I see around the world. It's construction, oil and gas, energy, defense, shipbuilding. But the truth is, any contract can have an arbitration clause in it. So more and more we're seeing intellectual property type disputes, IT disputes, pharmaceutical disputes being referred to arbitration. So there isn't really any restriction in terms of what you can arbitrate. There are still some areas where you can't go, they're called non-arbitrable, but generally you can go anywhere. I think certainly in the UK, if you look at domestic arbitration, so arbitration between two English parties, you don't get that very much nowadays. When the 1996 Act came in, it covered both domestic and international arbitration. The feeling was we would see more and more domestic arbitrations, but in truth, our court system is very good. We've got a very good commercial court, we've got a very good high court, and the parties are probably fairly relaxed about taking matters to the English court for resolution rather than arbitration. But it's different in the international arbitration world. So when you've got international parties, so parties from different jurisdictions or somebody investing in another country, we find more and more that their dispute clause in their contract is arbitration, taking it out of the jurisdiction of maybe the national courts or where the project is being constructed.
Yeah, can I just pipe in from the Canadian perspective?
Domestically, the Canadian experience is different than the English. I see more arbitration clauses in the domestic situation than less at the moment. If you do a large infrastructure project, say with Infrastructure Ontario, there'll inevitably be an arbitration provision rather than resort to the domestic courts. I can't tell you why that is and why the difference exists. It may be because, in Ontario as a federal, or in Canada as a federal country, we have a whole host of various independent court systems, and maybe they're worried about it ending up in the wrong court system. I think largely, certainly in the infrastructure space, at least in the Ontario context, every time there's a dispute, there's potential embarrassment for a government. So it may be the confidentiality, but I can tell you, we see a lot of domestic arbitration provisions, and I think we have, I won't opine as to the quality of the courts these days, but we certainly have good judges there if you want to find them, yet we don't have the experience we have domestically. I'm seeing more arbitration.
Bob, in a recent arbitration journal, it said that Canada was the second fastest growing center for arbitration in the world after Singapore. Why do you think there's a trend towards doing more arbitration? Why are you seeing this dramatic expansion of arbitration opportunities in Canada?
Well, in Canada and Ontario in particular, I think the answer is easy. It's obvious. It'll be obvious, I'm sure, to everybody here. But I see three reasons to go the arbitration route. And I even put them in order. Number one, you get to choose your judge. You get to choose your arbitrator. In Ontario, for example, there are 300 trial judges in the Superior Court. And in spite of the fact that several years ago we had an Attorney General, God bless him, who was a wonderful counsel, a wonderful lawyer, he decided that a judge is a judge is a judge. Some court reform followed from that any judge could take any case. Well, that's just nonsense, of course. So there are, believe it or not, and not to be quoted, is this a public gathering? Does this get printed? I better be careful here, but...
It might be printed.
Might be printed, okay, I won't make any. But in any event, let's put it this way. There are judges who are better at trying commercial cases than other judges. And there may be a minority of those. We have a wonderful commercial list court modeled in a way after the commercial court in the UK. Not up to their standard yet because we don't have as many of them. And the commercial list, so-called, contains a list of the kinds of cases that go to the commercial list, and it's fairly narrow. So it's not every commercial case that you can get into the commercial list. So it's interesting, the commercial list kind of behaves the way arbitrators behave. I mean, they get things done, they get it done quickly. But there's not enough of them, and there's not enough access. That's number one reason. You get to pick your judge. The number two, of course, is obvious. It's arbitrations, by and large, are confidential. There is the odd exception, which we may talk about later. But business people don't like to have their dirty linen hung out to dry in the public place, and there is a real advantage there to the business person who wants to arbitrate. And then I think the third reason, at least in Ontario and Canada, generally is speed. This speed, you get it done. in, you know, when I was litigating cases, I guess about the early, middle 80s, the lineup at the courtroom door was just huge. And you know, a client would come to see me, and we talk about getting the case tried in the next year, year and a half, and then they'd be back in a year and a half, and we hadn't got halfway through the discoveries. There'd been so many motions, etc. You know, a client would say to me, you know, when is this case ever going to trial? This would be about the third year. And I'd say, well, you know, we're now on a list. We'll get reached a year from now. And the client would say, well, is there not another way? And I would say, yes, there is another way. And at that time, there were a half a dozen people around in a place called ADR Chambers, mostly retired judges, and you could phone there and get your case tried before an arbitrator promptly and quickly, probably within about 6 months. So that started the arbitration route, and so and that's very attractive to business people, of course. So those are there are all kinds of other reasons,
Right.
expertise, etc. But those
John,
are the reasons.
other than Bob's 3, which are all good and valid, you're doing a lot of arbitration. Are there 2 or 3 other things that you think are particularly important?
Well, let me just, if I could just dovetail with Bob's just a little bit, just so people understand the pace of play. I just settled a case 3 weeks ago that I started in 2000. So it just got settled in the courts after 17 years. It did not have an arbitration provision. It was a hammer and tong fight with an accounting firm. Not all of them go that slow, but you know, that's the reality of it. I think you know, the other aspect of doing arbitration is, I mean, you get to choose your forum on an international. You get to choose your choice of law. The domestic forum will make a difference as to domestic law. When you choose it, will make a difference in some cases, and we'll talk a little bit more about that. But that's a key issue. You know, you can get to a point of neutrality in other parts where you have competing jurisdictions, where someone's not going to trust the domestic jurisdiction of one contracting party with the other. So there is an element to pick a third-party jurisdiction, England, Ontario. So there are elements that are helpful. Mark and I did Mark Crane is here, did an arbitration with Bob where we acted for a massive international company, $60 billion of sales per year, had a contract with a Quebec company, and they chose Ontario law and an Ontario arbitration provision. Bob became the arbitrator. Sadly, the arbitration clause was a mess, but we can talk about that later. But the point was Ontario, in respect to that, was relatively neutral. And it may be that the parties were concerned about the civil law in Quebec, but that's an advantage you get with choosing having an arbitration provision, as opposed to letting, you know, the laws of private international law, conflicts of laws we knew in law school, dictate where your proceeding's going to be.
Gordon, one of the issues that is near and dear to my heart is enforcement. So let's assume we win something. Can we enforce it? There's been a lot of change in the last number of years in that area, especially in arbitration. How is that an issue for our colleagues here to consider when putting an arbitration clause together?
I suppose it depends whether it's a kind of a domestic or an international arbitration clause. There's big differences there. So in the UK, if it's a domestic arbitration, it is relatively easy to enforce a domestic arbitration award, and generally awards are enforced pretty easily. Internationally, it brings into play quite a lot of different issues. But certainly one of the big advantages of international arbitration versus courts is that we have what's called the New York Convention, which I think is about 150 countries have signed up to. And basically, the purpose of the convention is to regularize the recognition and enforcement of arbitral awards. So if you have an award which is made, say, in London, provided you can find assets in one of those other 149 states, you can quite easily enforce that award in one of those other states using the New York Convention. So you take your award to Ontario, take it to the Toronto court, and ask the Toronto court to enforce it against some assets that are sitting in Canada. So it's a kind of a global treaty that say 150 countries have entered into, and there's quite a nice example at the moment that does involve Canada. There's a project in one of the African states, a road project that was cancelled, I think around about sort of 2000 or so, and there were difficulties trying to enforce the award because the African state didn't have a lot of assets in Africa, but the Canadian claimant with the award took it to the Canadian courts here and had it enforced recently against a jet that was on its way to the Tanzanian state. So you can enforce it, not, I wouldn't say easily in every jurisdiction, but it's a lot easier to enforce than it is a judgment. There are certain ways that you can challenge the enforcement, but they're quite narrow and they relate to things like public policy. You don't go to the local court and have the local court retrying the issue. They are supposed to recognise it and enforce it. So the New York Convention is a good thing.
How does that compare in practical terms? So if you're investing in a silver mine in Ecuador,
Yeah.
and you have a signatory to the UN Convention, how does that compare to not having an arbitration clause and suing in the local court when something goes wrong?
Well, it probably has lots of sort of different issues there. I mean, first of all, you've got to win in the local court, and if you're the foreign investor, that might in itself not be easy. That's not to say that all foreign courts rule against foreign nationals, but it is more difficult in sporting terms. You're kind of playing away from home, so you don't know necessarily the local court system and how to I suppose how to litigate in the local court. So there is an issue there to begin with, but also you have to then enforce it with the help of the local court, and you may find that some of those decisions are actually quite difficult to enforce because the courts aren't necessarily as supportive. But if you then try and take that sort of judgment out of that local country and take it somewhere else that doesn't have some sort of treaty with you, it's quite difficult to enforce a judgment in another country as opposed to the award. The award is governed, as I say, by the New York Convention. Judgments aren't.
Can I just add? I mean, I think one of the things that parties and business people have to consider when they get into risky ventures, and no one likes to contemplate it, but is the enforceability, because eventually you're going to want to enforce against assets. Assets are in jurisdictions, and it's the governing law of the jurisdiction generally that's going to dictate, including the treaty, which some countries have various provisos about what they'll enforce and not when they sign the treaty. Mexico won't do water, I think, as a national thing. I can't remember what it was, but there are various issues. You're going to have to go to domestic law. There's a wonderful case playing out in Canada, the Chevron case, which is where the Ecuadorian Indians who got a judgment against Chevron. It became a huge cause célèbre in the United States because it was proven that the judge was in the back pocket of one of the parties. They've come to Canada to enforce. Our former partner, Glenn Haney, who's the head of the commercial list, has got the case at the moment. And it's a fascinating fight to see if they can enforce it in Canada. They've been up and down in the Supreme Court of Canada. The enforceability against multinational companies, you're going to be up against the separate legal entities issues because of the ownership of the various companies. So they were looking to attach Chevron Canada. The ownership structure was separate than the Chevron that was the judgment debtor. All those things are things that if you're going to get into a risky venture, you better try to take some time to sort out in the front end.
You talked about one of the benefits of an arbitration clause being confidentiality, and obviously that facilitates an awful lot of things in an arbitration setting or a mediation setting. You told me when we were discussing today that you had a recent case where there was no confidentiality clause, and that proved to be problematic. Can you talk about that a bit?
Yeah, it was an interesting case. Those who are local, at least to Ontario, will know about this, not about the case, but this particular program. It's called the Blue Box Program in Ontario, and that's the recycling garbage that one puts out in the so-called Blue Box, and that's financed, that program, 50% by the municipalities of Ontario, and the other 50% by what I unkindly call the polluters. That is the manufacturers, the beer companies, the liquor companies, the grocery companies, the packaging companies, and so on, all the stuff that ends up in the Blue Box. They pay 50%, and I forget when the program started, but several years ago. And at the end of each year, the municipalities would present their bill to Stewardship Ontario, which was the organization of all these manufacturers, newspaper companies, etc. Present the bill, and the manufacturers would more or less write a check for 50%. There was a lot of discussion and so on, but finally they got to the point where they just couldn't get along any longer. So for the 2014 year, they decided to put the case to arbitration and have an arbitrator decide what the 50% share was. And this is a $250–60 million program. So I spent 30 days arbitrating this case. The first problem, however, was that there was no, in the arbitration agreement, was unfair perhaps to call it an agreement, but the arbitration framework, the document that came down from on high, had no confidentiality provision. And so the municipalities, represented by one council, all 250 of them, and said, we want this arbitration in public. And I sort of said, well, what's the argument? They said, well, arbitration's always in private, said the manufacturers, and the municipality said, we operate publicly. So I was given a whole brief of sophisticated arguments on this issue. There was no law in Ontario, no law in Canada. Everybody assumed that arbitrations were confidential, arbitrations were in public. There was some Australian authority which suggested they could be. And then there was a line of English cases in the Court of Appeal, which I don't know if it's changed since because I did this case 2 years ago. But the English cases, which I ended up relying on rather than the Australian cases, suggested that there was a presumption of confidentiality, presumption that arbitrations are to be in private, but the presumption could be rebutted. And rebutted, and one of the ways to rebut the presumption was to show that the public interest demanded that the arbitration be heard in public. So at the end of the day, having found that line of cases, there not being any authority to the contrary here, I held that a $250 million case for which the taxpayers were going to pay half of that, roughly, the public interest trumped the presumption of confidentiality, and the case was heard publicly. The truth of the matter is that the details of it all were so completely boring that nobody really ever showed up. The odd time somebody would sort of trickle in off the street, and I would wonder who that person was. If it was a newspaper reporter or whatever, it always turned out to be the next witness or something. So, but anyway, there you are. And when the parties sat down, the regulatory authority that sort of governs this program, they set the terms. But if the parties had sat down in advance with the regulatory authority and say, this is what we want, at least they wouldn't have been taken by surprise. I suspect in that particular case, the result is going to be that it's in public. But there's an example of no confidentiality provision, the arbitrator deciding that the public interest trumps confidentiality.
Gordon, let me ask you the other side of the coin. Can you give an illustration to the audience of a circumstance where a well-considered arbitration clause was used to the benefit of one of your clients?
Well, I suppose, I mean, kind of history really in relation to a number of the big power projects in the 90s in the likes of India and in Pakistan, where projects were being either constructed or had been constructed, and the state governments were either changing laws or imposing tariffs, or in one case, in effect, terminating the contract. Now, the arbitration clauses kind of serve two purposes. One is if there's a dispute, you can have that dispute resolved somewhere outside the country, but having an arbitration agreement in place to begin with does actually put a little bit more pressure on states to behave in a slightly different way, because I suppose the arbitration world, and I hear what Bob says about confidentiality, the arbitration world and the political world knows about disputes that are going on all the time. And if you've got an arbitration agreement and you keep telling the state there's an arbitration agreement, we'll take you to arbitration rather to court, there is probably a slightly different reaction from the state because it doesn't want things taken out of the state and being kind of recognized in a slightly different kind of international forum. So I think certainly when you've got contracts with state governments, arbitration clauses are really important. I do think it puts extra pressure on them to accept the contract terms.
John, let's talk about one other clause that is often found in an arbitration agreement, and that is there's no right of appeal. And I take it that a lot of people think that's a good idea because it ends the proposition. It's over and done with. Let's take Ontario, for example. If there is an arbitration clause and it says no appeal, what do the courts do, if anything, if the losing party tries to take that to court?
They throw them out. I mean, the reality, what's going on now is it's a travesty insofar as appellate review in Ontario is falling by the wayside in almost every regard, and it started with a case in the administrative context called Dunsmuir. They basically gave such wide deference to decision makers that it had to be unreasonable. And then they've started to import the administrative concept into other areas, including the interpretation of a contract, and now also into arbitration. Arbitration has always been, in the Ontario context, very deferential, way more deferential than other jurisdictions. Bob will tell you about some of the other ones. But in the Canadian context, you have a very limited right of appeal, almost to the point where it's only if the arbitrator exceeds their jurisdiction do you get an opportunity to actually have it reviewed. There are contracts, and I've got one at the moment, a very sophisticated contract, where it has, contract provides a full right of appeal. Even with a full right of appeal, the courts are saying, you know, you've got three elements. You've got an appeal as of law. Yeah, we're going to take the stand out of the administrative law context saying that don't be fooled, courts, that this is an appeal of a legal issue, because they're mostly factual, so don't buy into that. Limited it there. Then they say appeal as to fact is reasonableness. God knows what reasonableness is. You can drive a truck through it. So the chances of overturning an arbitrator saying they were unreasonable is going to be very difficult. And mixed fact and law, they basically said really that's back to reasonableness. So the reality is, on the good side, there's going to be pretty much finality on your arbitrations in Ontario. On the bad side, if you get a wonky arbitrator, no offense, Bob, they happen, you're going to have a hard time having appellate review. And my own view is the rule of law requires there to be appellate review at some level, because that keeps everybody honest in the system, and our Ontario's sort of given up on it, and Canada particularly as well.
Well, if I could just throw in a word here in defense of my judicial colleagues and in defense of the Supreme Court of Canada, which I never defend, and certainly when I was on the Court of Appeal here, I never defended them because they weren't that kind to me. But in any event, the case, the Dunsmuir case that John speaks to, is, of course, a judgment. It comes from New Brunswick, John, and it's and of course it's a case of the Supreme Court which says the test is now reasonableness. Now, before the court said that, the Supreme Court of Canada had said, well, there are 3 degrees of reasonableness, and you had to figure out what kind of reasonableness you were dealing with in any particular case. It really got ridiculous. So I at least sort of give my hat a nod to the Supreme Court for trying to simplify it. I guess they haven't, because we'll still be fighting about what reasonableness is forever. As far, I don't know why John is complaining about the courts kicking litigants out that have arbitration clauses. As I sort of gathered, you were suggesting it's more business for him, more business for you. And the Ontario courts are extremely deferential to an arbitration clause. And we see an arbitration clause, and you just send them back to the arbitrator in this province. John said I would elucidate the other provinces. I really don't follow the cases in the other provinces as much as I should, but BC and Alberta certainly are less kind to the arbitral process and less kind to arbitrators. And from the odd case that I see out of both British Columbia and Alberta, they are not reluctant to intervene in an arbitral decision. But in Ontario, we've certainly, as some people might say, drunk the Kool-Aid here. Arbitration is where it's at, and the courts keep their hands off. So if you've got a good arbitration clause and a good arbitrator, you're in good shape here.
Gordon,
And good counsel, too.
well, thanks. Gordon, let me, we're coming to the end of our time, and before we ask any questions, let me ask you to wrap up with sort of a takeaway for our friends here. We've talked about these details, these benefits, these examples. Why is it most obvious for business people to take this issue seriously? How does it benefit them, in your experience, on a global basis, as opposed to simply taking your chances with no thoughtful dispute mechanism?
I think the main issue is enforcement, and going back to the New York Convention, if you want to enforce a decision of a court or a tribunal, it's much easier to enforce the decision of the tribunal because of the New York Convention. So I think that to me is the overriding thing, and I think we had other examples earlier of the advantages of arbitration. So neutrality, so you take it away from the local court. The issue of confidentiality can be hugely important. In certain disputes, for example, construction disputes, the ability to appoint an arbitrator or arbitrators with experience in that specialist area, again, is really important. I think the issue that the arbitration world is finding it difficult to deal with at the moment is time and cost. And we've heard a few things today about it can be quicker to arbitrate. That might be right in some jurisdictions, and if you look at some of 17 years in Ontario is obviously a very long case. I've got examples of 30 years in other countries to have litigation from start to finish. But if you can have an arbitration that takes 18 months, that's pretty good. Arbitrations are starting to take a little bit longer because counsel are playing slightly different games and treating arbitration a little bit more like litigation in some respects. I think the biggest issue is cost. And the biggest benefit maybe 15, 20 years ago of arbitration was cost, because the whole point of arbitration was to try and get a kind of a condensed process through quite quickly and relatively cheaply. But again, because arbitration has kind of taken over this dispute world, with it comes lawyers who practice in a slightly different way, and arbitration has become, to a certain extent, sort of big business for lawyers. And I think the institutions have recognised that. So the ICC, SEAC, the LCIA, and what they're trying to do is bring in expedited processes to take some of those disputes away from the kind of the 2 or 3 year process and bring them back even to a kind of a 6-month process. So it's an issue in the arbitration industry, which it is, that we have to deal with, which is trying to bring some of it back to the kind of, it's also important to save time and costs, and that's what we've got to work on.
Sometimes you just have synergies you didn't expect. That is a completely perfect segue into panel 2 on cost. Anyway, before the group leaves, and you certainly can ask any questions you want after, but does anybody have a question about this first panel's discussion that they want to ask now? And if you do, please go ahead. Just stick your hand up like you're in school. All right. Yes?
So the three of you primarily practice on the implementation side of arbitration. What I'm wondering is, what would your biggest piece of advice be for a drafter to deal with the problems that you see on the implementation side at the level of actual arbitration?
So, I mean, I'll speak from my perspective. I mean, I think if you're going to be a drafter, you got to have a vision of what the dispute is likely to look like and what side you want to fall on. I mean, I was telling a gentleman here earlier about a case I'm involved with. It's in the papers a lot, but in that case, the owner, we'll call the owner wanted to terminate the supplier, but there was an arbitration provision, dispute resolution board type situation, and the court said you cannot terminate for default until you've gone to the dispute resolution board, which meant that from the date the default happened to the date they're going to terminate is going to be 18 months or whatever it takes. Now, if you're the owner, and that when we actually went to court on that, and we were successful. We were acting for the supplier. We were successful. But the owner then can't terminate. So if you're an owner, you look at that decision saying, you got to be very careful, because if what you really want to do is terminate, particularly if it's a big infrastructure project, you want to be on time and you got someone holding you up, that's a real problem. You better look at your clause to make sure it's absolutely perfect. From a supplier perspective, well, it's only fair that I have a determination that your characterization of my default allows you to terminate. But you would see that from a entirely different perspective if you're the owner or the supplier. And if you're drafting, you better think about that, because lots of lawyers out there like myself are going to find any avenue we can to advance our client's case. And you better think about it up front. And they don't, a lot of times.
Let me just add a quick tip. I've got in my hand here a document called IBA Guidelines for Drafting International Arbitration Clauses. Read the table of contents to this document. It's a superb checklist. And then each subject in the whole thing goes into some detail as to why you want a clause or don't want a clause and what kind of clause you should have. Excuse me, it's really good.
Actually, I didn't know you snuck that in, Bob, so we will circulate that to the crowd after this.
Can I just ask one to the last thing? I think ask a disputes lawyer is often the answer that I give to people when I'm giving seminars on drafting dispute clauses. I think it's very easy to take the ICC or the LCA standard form and just put it into the agreement. I mean, it works. it's a standard form provision that works. But if you're thinking about a supply contract that you know the disputes are going to be $500,000, why would you think about an ICC arbitration possibly with 3 arbitrators? The costs involved in that may be far more than the actual dispute there is. Or if you're going with an ICC clause at the moment, think about whether or not you go for the fast track process. Again, a $500,000 dispute, you should put through the fast track process if it makes sense. So I think you know the kind of the world of arbitration is changing, and I think those that practice in this area just have a slightly different view than perhaps the standard form provision that, as I say, works, but does it necessarily work best for the client or the project that you're working on?
You have a question, Tom? Or
There's actually an observation which might in part answer that question, which is that, and also tying with what Gordon said about perhaps not using the standard clauses, but also to make sure that you really do take care on those clauses. For something, for example, as basic as, have you got the right institution that you're using? Just to use a real life example, I've got a case at the moment where the parties, they've got their arbitration clause, it's a complete mess, they clearly didn't take any advice on it. So they basically chose a non-existent institution and no rules. And the effect of that is that you now have an ad hoc arbitration where there's no mechanism to appoint the arbitrator. The only place they can get an arbitrator from is from the court of the seat, which is Zurich, and that takes at least 6 months. So they can't get the proceedings started for 6 months. Meanwhile, the other side is, you know, running havoc with running off to court and getting injunctions, all the things that you thought wouldn't happen when you had an arbitration. So if you don't really take care at the beginning and have an absolutely, to the extent you can, really nail down a clause which deals with all of those things, who the arbitrators are going to be, what the institution is, what the seat is, you will end up with a mess at the beginning. And so that's in part, I guess, the answer to your question.
Can I add something on to what Tom said? Well, no, but I a number of years ago, I acted for a law firm who failed to file with the Institute on time, although served them the notice. So kind of like they didn't appoint the arbitrator. And the domestic law's limitation period had gone. And that went the arbitration, and so did the lawyer who got sued, who I acted for. But it is a real knock-on effect. And I had one last week. They come in and they've got these highly complicated arbitration provisions, and you got to mediate, then you got to negotiate, then you got to mediate, and then you got to give time. And all of a sudden, the parties don't want to have the fight. They want to see if they can negotiate. They can't. They come to me. I said, well, you can't get all this done and get an arbitrator appointed before the expiry of the limitation period. I've had that twice in the last year. That's a real problem because as Gordon says, they just pick them off the shelf without any regard to the fact that they're not going to be able to, they don't have any regard to the reality of what they're involved in.
Or don't pick them off the shelf.
Yeah.
You know,
Yeah.
I mean,
Or
most
don't.
of the time.
Or yeah, as Tom said, make it up.
anyway, thanks to this panel, and we're going to go right into our second panel.